Mr. Bailey.
Well, Lords, I want to restart first by trying to alleviate some of the frustration of not having the underlying contractual documents. And I think we can do that by looking at the first instance judgment of Judge Pelling, starting at paragraph 15. That's E5, page 166.
Thank you.
I think this explains why the parties decided not to burden the court with all of the various underlying documents. Paragraphs 15 to 18 set out the process essentially as follows. You'll see in paragraph 15 that there's an initial purchase order. That's sent by the customer to D&D. And that's then forwarded by D&D to Angove. Angove then issues an acknowledgement of order, and that identifies the customer and D&D as the consignee. And the acknowledgement is copied to D&D by email, which we see bottom of page 166, top of 167. Then the wine is dispatched. We see paragraph 17. Consignee still identified as being both D&D and the customer. And then the last three lines of paragraph 17, the shipping documentation included a commercial invoice that identified the consignee as being both the D&D and the customer. But, my lords, the point remains the invoice was addressed to D&D. Mm-hmm. And the document that we see in paragraph 18, the documents included the credit note. So that's how the underlying contractual documentation flowed. I now want to just deal with the point that my Lord Neuberger raised just before the lunchtime interval, which is this, that what happens if the customer decides to pay Angove directly?
Yes.
And in my submission, the answer must be that looking at the machinery under clause 22, that payment must be treated as a payment received by D&D and then paid to Angove in satisfaction of D&D's liability to pay Angove's invoice.
Well, you say that it must be treated as such. I can see that it might have the same effect for certain purposes, but if the money is paid directly to the seller, then there's no way in which the payment route can secure the agent in respect of any liability owed to him.
But, my Lord, as a matter of contract, as between D&D and Angove, that's how the parties have elected to treat the flow of payment, so that there remains a liability owed by D&D to Angove to pay Angove's invoice. Yes. And we can test this in an insolvency situation. So, for example,
you have to test it with the insolvency of Angove, wouldn't you?
Yes. Yeah.
Right.
So in those circumstances, there would essentially be an insolvency set-off, and that the claim that D&D would have as against Angove would be for the 5% commission. It wouldn't have to put in a proof for the full amount received by
But
Angove.
I don't understand how the insolvency set-off would work. The money has ended up in the hands of the creditor, namely the seller of the wine. So the seller is satisfied. The only subsisting liability is for the commission, and that is a personal liability, for which, if Angove was insolvent, D&D would have to prove. So the effect would be that they would not be secured because of the way in which the buyer had chosen to exercise an option conferred in the contract itself.
Well, Lord, the difficulty there is that the invoice which Angove has issued hasn't been dealt with. It's still on the books. There hasn't been a credit note in relation to Angove's invoice. So there's still an extant liability owed by D&D in respect of that invoice, and that is why...
An extant liability to pay the price? What is the extant liability?
Well, the extant liability arises if we look at 22C. This is E7, page 198.
Yeah.
So it's expressly agreed between Angove and D&D that it's D&D who will pay the amount of Angove's invoice.
Yes.
So if the payment is made by the customer direct to Angove, and Angove having issued an invoice to D&D, that liability remains outstanding.
Well,
So,
what liability? There can't be a liability to pay the invoice price. D&D can't possibly have a liability to pay Angove the price if they've already received the price from the buyer.
My Lord, that's right, but the way it works is that the payment by the customer to Angove is, in accordance with this mechanism, treated as a payment by D&D in satisfaction of Angove's invoice
Quite
to
so, but the difference is that because it has bypassed D&D, D&D has no ability to help itself to its price in full, to its commission in full. Instead, it's got to prove for it. And therefore, the interest, the security interest for the commission is illusory.
Well, my Lord, in those circumstances, it's not just treated as a payment by D&D of the invoice. It has to be treated as a receipt pursuant to B from the customer and a payment of the invoice under 22C.
But how is D&D secured in respect of its commission? Do you agree that it would simply have a dividend if Angove was bust?
It would have a dividend for the 5% commission.
Exactly.
But that's because it has effectively overpaid. Because the payment would have been made in full from the customer. So the full amount of the invoice, which has been claimed, has been paid by the customer. That has made its way to Angove. And so if that is, as I submit, it should be treated as a payment received by D&D and then paid on to Angove, that amounts to an overpayment. Right. So in that sense, it is actually recouping the monies.
But the net result is that there's a net liability of 5% owed by Angove to D&D, for which D&D must prove if Angove has gone bust.
But it's predicated on D&D having received the money.
Absolutely. Or deemed to have received it. But the fact is, in that scenario, D&D does not have a security for its commission. It has to prove for a dividend. So that any security interests conferred by the contractual route of the money is illusory, because it wouldn't apply if the contractual option of the buyer to pay directly was exercised.
But, my Lord, the position remains that it's still deemed to have taken...
But what use is that if it's not a security? I mean, it might be deemed to have gone via D&D, but it's still not a security, because it doesn't secure anything. It doesn't give them a prior claim, which is the whole object of a security.
Well, Lord, if I could put it this way, let's take the example or hypothetical scenario of D&D obtaining payment in full from the customer, right, pursuant to 22B. It then pays, by mistake, it pays the full amount onto Angove. Mm-hmm. In those circumstances, its security is achieved in the sense that it has obtained the payment from the customer. That is its security. It's just made a consequential error of paying too much to Angove.
Well, that's not really a very close analogy, is it? If you imagine a situation in which D&D is secured, but by mistake it pays over the sum anyway and loses it because of an intervening insolvency, or loses most of it. That's a completely different situation. We're envisaging that a contractual option in the buyer has been exercised in a way that bypasses D&D and therefore prevents them from helping themselves and leaves them with the only right they have is to prove in the liquidation of Angove.
Lord, it's the receipt from the payment from the customer which stands as the security in that sense of for D&D's interest. So in the example I've put forward, there is a deemed receipt, and so whilst there is an illusory result, as your lordship puts it, the fact remains that the security has been realised by the deemed payment by the customer to D&D.
Right. Well, I'll think about that one.
Before lunchtime, my lord, your lordship also asked about the accrual of the right. And my answer to that question is as follows, that, as I previously admitted, the right is the right to the commission, and that accrued on the sales being arranged. Now, that gave rise, under Clause 22, to a bundle of rights which the parties had agreed could be relied upon to satisfy the entitlement to commission which had accrued. Now, as to the right to collect the monies from the customer as part of the mechanism to satisfy the right to commission, that right accrued on the date of the bill of lading, because that is the date on which the invoices became payable.
Where do we see that?
Well, the Clause 20 so payment is to be made on or before 90 days from the date of bill of lading, and that's the period also. If we look at Clause 22C, which refers to the period, I mean, it erroneously refers to Clause 23, as Mr. Moriarty pointed out, but that should, it's common ground, that should be a reference to Clause 20. So both the customer and D&D are subject to obligations to pay the invoice sum from the date of the bill of lading, and there is a 90-day credit period from that date. Lords, I also want to turn to one word in particular which appears in paragraph 22b, which is the word responsible. And Mr. Moriarty, when he was dealing with this clause, elided it with the word obligation, which in my submission is not correct. The use of the word responsible, in my submission, is aimed at demarcating the risk for payment from the customer. As Mr. Moriarty pointed out, previously, the payment was to be made by the customer to Angove. So the risk for the whole amount of the invoice was with, or the customer's risk was with Angove. Whereas here, it's being reversed. The risk is now being placed, the credit risk of the customer is now being placed fairly and squarely on D&D. And so all that's being said here is that D&D has to pay Angove's invoice, and if it does, it is responsible, that is to say, it bears the risk of seeking payment from the customer. And to phrase it as an obligation in my submission is erroneous, which we can see in the following example. If D&D pays Angove under its invoice, what obligation does D&D have as a matter of contract, a contractual duty owed to Angove to collect in the sums. It doesn't have a liability, contractual liability or contractual obligation in that sense. It has a right to, but it is not duty-bound, having paid Angove to go and collect the sums for Angove's benefit.
So what does responsible mean?
Responsible means that the liability for obtaining or the risk of obtaining payment from the customer rests with D&D.
Is there anything in the agreement which sort of suggests that the machinery for collecting by D&D is a right, which is what you've got to say? I mean, the key is this is accrued rights, and you seem to be saying, well, this machinery somehow is a part of their rights. There's nothing in the language which suggests that it's part of their rights. Is there?
Well, Clause 21 sets out an obligation on Angove to pay D&D commission, so it has an entitlement. There's a countervailing entitlement.
No doubt that it has a right to the commission on payments sales have been made, but you've got to go further and say that 22B is part of the sort of package of rights to enable it to achieve that. And the language doesn't seem to suggest that, does it?
Well, it does in this sense, my lord, because under 22C, the parties have expressly agreed that it is D&D who will pay the amount of Angove's invoice. It has an overarching entitlement to commission. So if it pays, or alongside its liability to pay Angove's invoice, it must have the right to collect in the payment from the customer.
Well, yes, the difficulty is that right is somewhat undermined if it can't be required to pay Angove's invoice in circumstances where the customer has elected to pay Angove directly. I mean, I know you submit that they are deemed to have done it. That may or may not be right, but it's very difficult to see why this is anything other than a service. And therefore optional.
Well, my lord, there may be an option conferred on the customer, but it's not optional as between Angove and D&D.
But it's agreed between Anglo and D&D that the customer will have that option.
On the face of the terms and conditions, yes. I mean, the reality was that never happened, but because and as we see under...
Well, we're not really concerned with what happened, but
No.
the true construction of the contract.
No, my lord. But the true construction of the contract, in my submission, is that Angove issues the invoice to D&D. D&D has a express contractual obligation to pay that invoice. So bearing in mind that obligation, it must, in order to obtain its commission, have a right to collect the monies in from the customer.
What you're really saying is that 20, 21 and 22 read together represent a complete scheme whereby D&D is liable to pay the invoice. They're also liable to collect from the ultimate customer. They're also entitled to commission, but they have to take the commission out of what they collect, and that's a coherent scheme. And if it doesn't survive the determination in relation to a case where the transaction between D&D and a customer has started, then the scheme simply doesn't work. Because there's nowhere else for it to go. Therefore, it is an accrued right, and in particular there's an accrued right to commission because that arises on the transaction the contract being entered into with the customer. And that's the starting gun, and the rest flows. And you can't, the rest is, as it were, accrued from the date of the contract. And the same logic, you say, applies to the question of whether the third sentence, the third paragraph of the letter, is a permissible breach of contract, as it were, or whether it can't have effect because otherwise the contract doesn't work.
Well, yes. That's it in a nutshell. There are two very brief points on this before I propose to make it. Or one point, which is in relation to Clause 23. There is a marked difference between the operation of Clause 22 and Clause 23, because the liability of D&D to pay Angove's invoice under Clause 22 is not contingent upon receiving monies from the customer, whereas the liability of Angove to pay D&D's commission under 23 is wholly contingent upon receiving the sums from the customer. So to that extent, under Clause 22, there is an unqualified liability on the part of D&D to pay Angove's invoices.
And really you're saying that in addition, the Annex A, which enables the customer to pay Angove direct, is all very fine and dandy. That's a right given to the customer, but it doesn't alter the nature of the arrangement between the parties. It's a slightly awkward fit into 20, 21 and 22, but if one accepts the basis of your argument in relation to 2021 and 22, then you simply treat the payment as if it's, as it were, gone through Angove, through D&D, but they have to get their commission back on it.
Yes.
But as between the parties, that's obvious.
Yes, my lord. The parties' mutual rights and obligations are set out in this document, and they should be held to that bargain.
And one would sort of use the annex, as it were, insofar as it appears to be inconsistent, not to vary the contract, but to, as it were, to fit in with how it works.
Lord, can I then just turn to Clause 37? Because the first point to note here is that it applies in the event of termination for any reason whatsoever. So it's not limited to termination for insolvency under 36B. It's for any.
So it would include termination, unlawful termination, accepted repudiatory breach, presumably.
Well, yes. Well, it's for any reason. Yes. So
it wouldn't just be 36. It would be accepted repudiation.
Yes, for reasons wider than the contract reasons.
Yeah.
37A essentially sets out a reckoning exercise. It requires each party to pay to the other all money owing up to including the date of termination. So that we've looked at Clause 22 perhaps to death, but just to recap, there are no sums owing by Angove as at the date of termination, because the sum as between these parties, the sums that are owed are one, sums owed by D&D in relation to Angove's invoices. There are sums owed, this is in relation to Clause 21A. There are potentially sums owed under Clause 23, but we're not concerned about that. And the other instance in which sums may be said to be owing is in relation to the credit notes, which are set against the invoices which Angove have issued to D&D. So the only sums owing contractually are the payments from D&D to Angove under the invoices.
I wonder about that. I mean, if Angove has issued a number of credit notes to D&D, which presumably D&D can use against any sums that they hold due to Angove at any one time. That would be how it would work, couldn't they? They don't have to set one credit note off against one particular invoice. They can square it up. And if D&D don't have any funds in at that time, are you saying that 37A would operate so that Angove had no obligation to pay sums due under Clause 21A?
Well, there is, as a matter of fact, there is no payment being made by Angove under Clause 21A. Angove's not actually paying any sums. There's just a deemed payment, which is worked through Clause 22.
Well, I wonder about that, because the opening words are on termination. Each party must pay to the other all money owing up 22 and including the date of termination. That doesn't seem to me to be addressing deemed payments by the operation of other procedures. It's saying we do a reckoning now and see who owes who what, and it gets paid.
Well, but my lord, to answer the question of what is owing, one has to look at the terms of the contract to identify where the various liabilities arise. 22 does not impose on Angove a liability to pay any sums.
Yeah, but clause 21 does.
But clause 22 says anything payable under clause 21A is to be paid as follows. So one cannot read 21A in isolation from 22.
Yes, so you see 22 as restricting the obligation in 21A.
As defining it. And it's for that reason that it's not as straightforward as Angove would want to say, well, we simply owe you 5%. We'll pay you that as if it's a damages claim. There are no sums owing pursuant to this contract by Angove as at the date of termination.
Well, I find that a strange interpretation, because it seems to me that there is more force in Mr. Moriarty's point that there is the obligation of sums owing under clause 21A, and clause 22 is simply the mechanism by which it's recovered absent termination.
Well, my lord, the obligation still subsists under clause 21A, but the way that is to be discharged is in accordance with 22, and that's what underpinned the reasoning of the Court of Appeal. The Court of Appeal found that it must be implicit when you look at 21A, 22 and 37, that there is a continued right to collect the monies from the customers, because that's how commission is paid, and that's how the accrued right to commission is satisfied.
Thank you.
Lords, I now would like to turn to the question of whether the construction of the ADA, as found by the Court of Appeal, is inconsistent with the general rule that an agent's authority is always revocable by the principal. And I'll call that the general rule. My Lords, the substance of this appeal and the point of general public importance which is relied upon is that it is said by Angove that the manner in which the ADA has been construed by the Court of Appeal contravenes the general rule and generates real uncertainty over the circumstances in which an agent's authority can be revoked. That point is made in grounds of appeal paragraphs 13 and 14, which are at A1, page 35. So the question for your lordships on this appeal in my submission is whether D&D's contractual right and authority to continue collecting the payments, as found by the Court of Appeal, should be curtailed by the general rule, which operates even if the revocation amounts to a breach of contract. I should say, my lords, that for the avoidance of doubt, it's not the liquidator's position that there is anything wrong or unprincipled in the general rule. There are strong policy reasons why a principal who's conferred authority on his agent ought to be entitled to revoke that authority, even where the revocation amounts to a breach of contract. For example, where the authority is expressed in the contract to be irrevocable. Now, my lords, the policy reasons for the general rule are succinctly set out in the third restatement of the law of agency from the American Law Institute in their notes to paragraph 310. That's at F11 at page 363 to 364. It's in relation to the notes of paragraph 310, manifestation terminating actual authority, and then the notes on page 363 at B, under the heading power to revoke or announce actual authority. A number of points are made, which I would summarise as follows. Firstly, the agency is a consensual relationship which falls to be reviewed on an ongoing basis during the relationship. Secondly, enforcement of an agent's exercise of authority affects the principal's legal relations with third parties. Thirdly, since a principal's power to control the use of such authority is imperfect, the principal has power to call back what is, in essence, an extension of his own legal personality. And fourthly, the power to revoke authority reduces the principal's risk in retaining the agent because it does not require establishing a breach of duty by the agent. Now, my lords, with those policy reasons in mind, we'd submit that there is an important and fundamental distinction to be drawn between the authority to collect monies in respect of sales already concluded and the authority prospectively to conclude future sales and to collect monies on those sales. In respect of the latter, the liquidators accept that the termination of the ADA was effective to call back Angove's authority to arrange future sales under Clause 2 of the ADA, which conferred the general appointment. As to the former, in relation to concluded sales, it's the liquidator's contention that the termination had no effect on rights prior to the notice of the termination, which had been, in the language of the ADA, accrued, or in the eyes of the common law, unconditionally acquired. And we say that this is analogous to the position in relation to repudiation of a contract. In that scenario, the innocent party is not divested of rights which have already been unconditionally acquired by reason of the execution of his obligations before the contract is terminated. Those rights aren't swept away by termination. And in support of this, I'd refer your lordships to the judgment of Lord Wilberforce in Johnson and Agnew, which is at F30, page 607. And passages E to H on page 607, Lord Wilberforce cites a judgment of Mr. Justice Dixon in the case of MacDonald versus Dennis Lascelles, where he said this, that when a party to a simple contract upon a breach by the other contracting party of a condition of the contract elects to treat the contract as no longer binding upon him, the contract is not rescinded as from the beginning. Both parties are discharged from the further performance of the contract, but rights are not divested or discharged which have already been unconditionally acquired. Rights and obligations which arise from the partial execution of the contract and causes of action which have accrued from its breach like continue unaffected. And then further down towards the end of this dicta, the last 6 lines, but when a contract which is not void or voidable at law or liable to be set aside in equity is dissolved at the election of one party because the other has not observed an essential condition or has committed a breach going to its root, the contract is determined so far as it is executory only, and the party in default is liable in damages for its breach. So, my lords, imagine the example of a contract supply of widgets, which is to last for 12 months. The supplier sells 5 widgets in month 1 at £1 each, so he's entitled to £5. And then after 1 month, there's a repudiatory breach by the purchaser for non-payment. And then the supplier accepts that repudiatory breach and is discharged. In respect to the obligation to supply for the next 11 months, the supplier is discharged because that is an executory duty. In relation to the claim for £5 for the goods supplied, he's entitled to payment because that's an obligation which has been executed. In the same way, that termination of contract has no effect on the rights which have been unconditionally acquired, termination authority, we say, should have no impact on rights which have been accrued or unconditionally acquired by the agent prior to termination as a result of obligations which have been executed. So in this case, by the time of the termination of the ADA, D&D had acquired, we say, 2 rights. Firstly, the right to commission under Clause 21A, and secondly, the right to collect payment from the customers under Clause 22B in order to satisfy its entitlement to commission. And this was the conclusion which the Court of Appeal reached in paragraph 22 of its judgment at page 145. Now, Lords, we say there are good reasons of policy why this should be the case. The first and most obvious is that this is the manner in which the parties have expressly agreed to arrange their business relationship. They should be held to their bargain unless there is a more powerful policy consideration. Secondly, we say it would be strange and anomalous for there to be a material inconsistency in the way the law treats acquired rights. As a matter of contractual termination, the position is clear, as we've just seen. The termination has no effect on those rights, and it would be unusual if termination of authority, particularly an authority granted by a contract, would have a diametrically opposite effect to disturb acquired rights. Again, there would need to be, we say, strong policy considerations to justify that outcome. What policy considerations, we ask, are being advanced to support such a justification here? Why is it so important for Angove to retain and exercise the power to call back its legal personality in order to prevent D&D from collecting the monies? The residual authority does not involve D&D entering into legal relations with third parties. It also does not involve D&D's acting in a manner which is likely to be to have adverse consequences for D&D. So there's no sense in which D&D can be said to be acting rogue or running amok with Angove's personality. Quite the opposite. The authority involves D&D performing a limited role for the operation of existing legal relations with third parties, a role which has been expressly agreed by D&D. So if on the proper construction of the ADA, the right to collect in the money had been unconditionally acquired before termination, there is no good reason why the general rule should operate to divest D&D of that right. As Lord Justice Patten held in the Court of Appeal, in those circumstances, the general rule should yield to what the parties have agreed should be their respective legal rights and obligations upon termination. And the reference in his judgment there is at E2, page 146, paragraph 25. Further, my lords, the right to collect the monies from the customers is not a right which is exercised for the benefit of and in the interest of Angove. There is an authority given for the realization of that right, which is one which is not of pure agency. And so we say the usual principles of agency law are not engaged. Here, we say instead agency reasoning is being extended as a device to assist in the satisfaction of contractual rights and obligations. And in relation to that, I want to refer your lordships to an article by Professor Reynolds entitled "When is an Agent's Authority Irrevocable?" That's at F20, page 439. And it's the final paragraph on page 439 where he says this: "The principle of pure agency law, in the sense of the pure law of representation of persons by others, is clear that authority can be specifically revoked or terminated by death. But when the reasoning is being used for other objectives, it may well be that authority is not revoked in either case. It is only in what we may call the pure agency context, therefore, that the principles as to revocation or termination hold full sway." So in this case, D&D is not collecting in the monies for the benefit of Angove, but it's acting in accordance with the contractual scheme under clause 21A and 22 for its own benefit. So we're outside the territory of pure agency, and in the words of Professor Reynolds, the usual rule does not hold full sway. So we say the result of the Court of Appeal's decision is that it is not inconsistent with the general rule, but rather based on the rights and obligations and the exercise of those rights, the general rule isn't engaged because it is not pure agency. My lords, the next submission by the liquidators is that they are entitled to collect in the monies from customers because the authority to do so is what is known as an authority coupled with an exception. And this is a commonly accepted exception to the general rule, so I will just refer to it as the exception in my submissions. Angove contends that liquidators require permission to argue this point because it wasn't raised by them before the Court of Appeal, It is only right to acknowledge that that is correct. It was indeed not taken before the Court of Appeal. And we accept, on the basis of the wording of clause of Rule 6.33 in the Supreme Court's practice guide, that we do need permission. What I would propose to do, my lords, is to deal with permission at the end of my submissions on the argument, because the broad position of the liquidators is this, that the argument involved a pure point of law, and secondly, that the Court of Appeal reached its conclusions for reasons which substantively are equivalent to the exercise of the exception. So, with your lordship's permission, I'd like to develop the arguments and then deal with the question of permission after that.
Okay.
My lords, in our written case, we provided an appendix to setting out an historical review of the exception. I'm not going to trawl through that before your lordships this afternoon, but I would like to touch on a few authorities to explain the evolution of the exception and why it has come about. Its existence was recognised in the Digest of Agency Law, 1896, by Bousted, which we have at F13.
Thank you.
And it's stated under Article 129, which is on pages 376 to 377, as follows. Where an authority is given by deed or for valuable consideration for the purpose of effectuating any security or of protecting or securing any interest of the agent, it is irrevocable during the subsistence of such security or interest. But an authority is not irrevocable merely because the agent has an interest in the exercise of it. Now, my lords, Bousted then sets out some illustrations of the operation of the exception from page 378 onwards. The first of these is the scenario of A being indebted to B, gives B a power of attorney to sell land and discharge the debt out of the sale proceeds, and in that situation the authority is irrevocable. The authority cited for that is Gowson versus Morton, an 1830 case, and we have that behind tab F29.
A somewhat terse judgment.
Yes, typically brief for its time, I think. So, but the facts are on page 576, my lords. I think Mr. Moriarty set them out very succinctly earlier. JL was indebted under a bond for a debt owed by his son. He granted W. Forster, the creditor, a power of attorney to sell premises. Forster tried to present the premises for sale and received a deposit. Then JL sought to revoke the power and to stop the sale, and the sale was allowed through by the steward. And title was passed on by the purchaser to the plaintiffs, whose land it then became, and then there was an alleged trespass. And the issue is identified in the terse judgment of Lord Tenterden, CJ, on page 577. The issue was identified as follows. The question whether JL died seized of the premises in which the trespass was alleged to have been committed depended upon this, whether he could revoke the power of attorney given to Forster. We think that it was not a simple authority to sell and surrender the premises, but an authority coupled with an interest, for Forster was to apply the proceeds in liquidation of a debt due to himself and his partners, and there are several cases in which this has been held that such an authority cannot be revoked. As we saw in this section from Bousted in the Digest, he observed that it was an important requirement for the exception to apply was that the authority was given for the purpose of securing or satisfying the interest. This is illustrated by one of the cases in the bundle, Smart and Sanders, which is right at the end behind tab 39.
Right. Yes.
F39, page 857. My lords, we can pick it up with the judgment of Wilde CJ on page 864, where he identifies the issue. Substantial question in this case is whether a factor who has made advances on account of his principal has a right to sell the goods in his hands, contrary to the orders of his principal on the principal's making default and repaying those advances. And essentially what had happened here was that goods had been consigned by the principal to the factor for sale. Thereafter, the factor had made advances on the credit of the goods, and the issue was whether the factor was entitled to sell the goods to discharge that debt, despite the fact that his authority had been revoked. On the opposite page, on page 865, Wild CJ starts to deal with the authorities. It's the third paragraph down. He says this: on the subject of authorities being rendered irrevocable by an interest, not much is to be found in the law books. Well, my lords, despite the lapse of 168 years, that statement remains as true today as it did then. And he then goes on to look at Walsh and Whitcomb and Galson, and he starts his conclusion 5 lines from the bottom on the right-hand side as follows. And the result appears to be that where an agreement is entered into on a sufficient consideration, whereby an authority is given for the purpose of securing some benefit to the donee of the authority, such an authority is irrevocable. This is what is usually meant by an authority coupled with an interest, and which is commonly said to be irrevocable. But we think this doctrine applies only to cases where the authority is given for the purpose of being a security, or as Lord Kenyon expresses it, as part of the security, not to cases where the authority is given independently, and the interest of the donee of the authority arises afterwards and incidentally only. So, my lords, in that case, the reason why the factors argument failed was that there was no coincidence between the authority and the interest. The authority was not given for the purpose of protecting the interest claimed. That interest arose subsequently and separately after the authority had been granted. So the decision is based, we can see, on the premise that the grant of the authority must be intended to serve an interest of the agent. Again, in his article, Professor Reynolds addresses the rationale for the exception. That's going back to F20, page 435. Under the heading, authority coupled with an interest, he wrote this: there are, however, cases where authority is actually conferred in terms that purport to make it irrevocable, and the law recognises the irrevocability as such. The recognition takes the form of treating the act of the supposed agent as binding the principal, despite the fact that the principal is purported to revoke the agent's authority specifically, or that he has died or become mentally incapable. These cases are usually in English law referred to as cases of authority coupled with an interest. The interest is that of the agent in carrying out the authority, and herein lies the key to the organising idea of this part of the law. We are here really not in the general law of agency at all. The central idea of agency is that of someone who acts on behalf of another and in that other's interest. It is for this reason that agents in general owe fiduciary duties and their authority can be revoked. But in these cases of authority coupled with an interest, the agent acts and exercises authority in his own interest. We've therefore a case where agency reasoning is deployed to achieve a different effect from the paradigm case at which it is directed. And my lords, I've already taken your lordships to page 439 and the excerpt there, which picks up that point further. The point is echoed again in F14, my lords, in the latest edition of Balstead. I'll just give you the reference, if I may.
Yes.
F14, page 391, 7 lines down, beginning as already stated.
Sorry, which page?
391. 7 lines down, as already stated.
He says agency is here a device for supporting or conferring a property interest. Did you say that has happened here?
Well, my lord, I'm going to address to you on whether or not for the interest to qualify it has to be a property or security interest in due course. But we say that the authorities do not support a circumscribed approach to say that it is only limited to security or property rights.
Well, I understand why you would say it's not limited to property rights, but when you say it's not limited to security, doesn't require that it should be a security. Are you suggesting that it would be a sufficient interest, therefore, that the agent had an interest in earning his commission? I thought that you had disclaimed that suggestion.
My Lord, we say there is a fundamental distinction between commission in the sense of being interested in the exercise of the authority in order to earn commission.
Yes.
And commission in the sense of commissions which have already been earned. The authorities talk of a right to earn. Here, we are dealing with commissions earned. And I will address your lordships in some further detail on that in due course.
And if the relevant interests don't include the right to do the work and earn the commission, all that's left is a security for debts. Isn't that right?
Or it's been put in the authorities, Mr. Justice Coleman in Lloyds and Leeds put it in terms of ensuring, it's used as a means of ensuring that an obligation owed to the agent is fulfilled.
Yes, well, that's a security, but it doesn't necessarily posit a proprietary interest.
No, well, if your Lord asks me, is it security in the sense that it's aimed at ensuring that the principal be held to his bargain, then yes, I would say it's security in that sense, but not. It's not security in the sense.
It's more than
of
that. It's a right to intercept money. It gives you a priority.
Yes. My Lords, Angove argues that the exception does not apply in this case for two reasons. Firstly, it says that the purpose of giving D&D the authority to collect the sums from the customers was not to protect D&D's right to payment of its commission. Instead, it claims that the purpose of the authority was to facilitate the collection of monies, quotes, for the benefit of Angove. Secondly, it says that the exception does not apply because the interest in question is a mere right to be paid commission. But turning first to the purpose issue, that whether the authority is granted for the purpose of serving D&D's interest is, as my lords noted earlier, a matter of construction. And as I've already submitted to your lordships, and as found by the Court of Appeal at paragraph 29 of their judgment, the purpose of clause 22b was essentially to enable D&D to do two things: to recoup its outlay expenditure payable to Angove, and to receive its commission in the form of the margin between its invoice to the customer and Angove's invoice to it, net of the credit note. And that was in circumstances where it was subject to an unqualified liability to pay Angove, with the commercial risk of payment by the customer being left fairly and squarely with D&D. And my lords, all of this is consistent with the first instance finding of Judge Pelling, not cross-appealed by Angove, that monies collected by D&D were not held on trust for Angove during the currency of the ADA. So in other words, instead of collecting money for the benefit of Angove, D&D was collecting money for itself in order to satisfy its own interests. It was not gathering in assets which were beneficially owned by Angove. So that's the purpose issue. Turning next to the commission issue, it's accepted that not all interests on the part of the agent are capable of attracting the application of the exception. It's commonly said that a right to commission will not suffice, and the derivation of this we can see from the Digest of Agency Law in Bousted at F13, 376 to 377.
Yeah.
It's where we looked at this before, but I think it is important just to labour the point. It's on page 377, 3 lines down, where Bousted said, "But an authority is not irrevocable merely because the agent has an interest in the exercise of it." There's no reference there to commission. So the emphasis is on being interested in exercising the authority. But in the more recent edition of Bousted, which is on tab 14, page 391, five lines down from the top, the authors there suggest that the mere right to earn commission is not such an interest.
Yeah.
Now, what one might ask is the explanation for the exception to be limited in this way. The explanation is proffered by Professor Reynolds, again in his article F20, that's at page 439. In the second paragraph on that page, he wrote this: the limit of this reasoning is obvious. Agents can act gratuitously, but normally they act for remuneration, and normally within that for commission. If the agent expects authority not to be revoked because the principal has promised not to revoke it, he may reasonably expect commission and make arrangements by way of capital expenditure and so forth, which are posited on the basis that he will, future tense, continue to earn commission. Nevertheless, his expectation that he will earn commission, even when consolidated by such expenditure, does not give him a sufficient interest to prevent revocation of his authority. His remedy for that lies in damages for breach of contract, and even here it would be safe with a very specific promise not to revoke. So the reasoning for this limitation of the exception is the interest going forward of being able to perform the function and earn commission. The authority cited in support of that, and which is a case which Mr. Moriarty relies principally on this point, is Dowd and Dixon and Co. versus Williams. That's at F2. Page 261. And the judgment, again another admirably brief judgment on page 262 of Mr. Justice Vaughan Williams, as he was, where he said that he could not exceed the proposition that if a man authorises an agent to collect debts for him at a commission for 5 years, that authority cannot be revoked, and the agent is entitled to say, I will go on collecting the debts in spite of the principal's revocation. So again, that's prospective interest as an agent. My lords, the same point arose in Temple versus QBE, which we saw during Mr. Moriarty's submissions. There, what was being insisted upon by the agent was the right to continue to manage the runoff cover in relation to the insurance policies that had been underwritten. And the interest that was being relied upon was an interest to carry on doing so, to take premiums, deduct commissions, and also to maintain relations with the cover holders, who are the solicitors. And that was seen as a purely commercial interest. And we've seen the judgment of Lord Justice Moore-Bick, which, just for your reference, my lords, is at F6, page 331.
Yes.
Which your lordships already have. So, my lords, the effect of these authorities, rightly, we say, is to prevent D&D from insisting upon the continuing exercise of its authority to conclude future sales on the basis that it has a commercial interest in so doing. That's to say, earning future commissions. But these authorities, which support the limitation of the rule, say nothing about commission for sales which have already been concluded, and in respect of which D&D has an accrued right to commission. So they present no obstacle to the case being advanced by the liquidators. It comes to this in substance, my lords. There's no real difference between this case and Galson. in Gowson, the agent had a right to payment and he was given an authority to sell the principal's manor in order to satisfy that right. In this case, as at the time of termination of the ADA, the position was identical. D&D had an accrued right to payment. Pursuant to that accrued right, it was entitled under Clause 22 to collect the monies in order to satisfy that right. So the position in Gowson, in that sense, is on all fours. The fact that the right in question is a right of payment or commission or some other form of remuneration should not of itself be determinative. Simply pigeonholing the right in that way is substantively misleading. When the authorities talk of the right to commission, in substance they are, in shorthand, referring to the continued exercise of the authority in order to develop commission. And the liquidators accept that such a right does not engage the application of the exception, but that's not a right for which they contend in this case. My Lords, I now want to deal with the question of whether the qualifying interest must be a security or proprietary nature. As to that, if we can go back to Bowsett and Reynolds at Article 118, which is at F14, page 389. Well,
Yeah.
The first paragraph under the article sets it out. At common law, where the authority of an agent is given by deed for valuable consideration for the purpose of supporting or effectuating any security or, brackets, perhaps, of protecting or securing an interest of the agent, it is irrevocable during the subsistence of such security or interest. And then, in support of that, the authors refer to the commentary below in 10.007. The point is, first point to note is at 10.007, 4 lines down. The editors say that authority can be irrevocable, but this is only where the notion of agency is employed as a legal device for a different purpose from that of normal agency to confer a security or other interest on the agent.
Yeah.
So there's a reference to other interest. But then when we go down to the bottom of the page, there's a reference to the orthodox contemporary exposition that the authority is irrevocable where it accompanies a security or proprietary interest. Now, my Lords, it's fair to say that that view, that more restrictive view, is not wholly endorsed by the relevant authorities. And in particular, there's a decision of Mr. Justice Coleman in Lloyds and Lees, which is at F5.
Thank you. Yep.
In particular, at page 303, passage G, he said this. This is having looked at Smart and Sanders and Walsh and Whitcomb on the exception. He said this: read in its context, and particularly having regard to the very limited previous judicial authority on which it was based, it is, in my view, quite impossible to treat this case as laying down any inflexible principle to the effect that nothing less than a security interest can justify the irrevocability of an agent's authority. No doubt agencies will not normally be irrevocable because in the nature of the transaction, the consideration given by the agent would not have purchased the relationship, but merely the agent's entitlement to be paid his commission in relation to performance. Then he refers to the policy of master and servant set out in Bowsett and Reynolds. And then he says, however, there cannot be any conceptual basis for confining irrevocability of the authority of an agent to cases where the purpose of his authority is to secure his money interest. In the authorities under discussion, the purpose of preventing the revocation of the agent's authority is that the perpetuation of the authority is necessary to provide the agent with a means which is under his control of ensuring that some obligation of the principal for the benefit of the agent is performed. The inability of the principal to withdraw authority is what ensures that the principal will not be able to avoid satisfying his contractual obligations. So, as Mr. Justice Coleman says, looking at the history of the exception, there's no justification for confining it to security or proprietary interests. And in any event, applying it in that way only begs the question of what constitutes a security or proprietary interest. And as my Lord Sumption I identified, in one way, having a right to intercept monies passing through one's hands could be seen as a security. In the same way that in Gaussen, the right for the agent to intercept the monies could be seen as a security because the payment of the debt had been appropriated to the property. My Lords, I'd only add further on this point the point we make at paragraph 61.2 of our written case.
Yeah.
That's where we refer to Section 4 of the Power of Attorneys Act, which preserves the irrevocability of an authority which has been given not only to secure a proprietary interest, but in the alternative to secure performance of the obligation. We've included in the bundle the report of the Law Commission at F16. At page 417. And this is the report of the Law Commission which ultimately found its way into the 1971 Act.
Thank you.
On 417, paragraph 33, the report refers to recommendation A. We see that on the opposite page under paragraph 32.
Yes.
And that recommendation is essentially what was translated into section 4 of the Act. Going back to paragraph 33, the Law Commission said that that recommendation in effect restates the common law position when a power is given by way of security, thus conferring an authority coupled with an interest. So, my Lords, we see from this that the Law Commission's analysis of the common law was that in order to fall within the exception, the right concerned did not have to be of a security or proprietary nature. And secondly, we see that the Law Commission did not consider there to be any need to alter or qualify that position at common law. Aside from technical requirements such as signature, there is no distinction in substance between a power of authority and a common law grant of authority. Both are means by which authority is granted to the third party. Equally, there is no need, we say, to draw a distinction between the two forms of authority for the purposes of applying the exception.
Yep.
My Lords, that deals with the arguments on the exception point. I just want to deal with permission. We have set out in the written case the reasons why we say permission should be granted. I just want to highlight these points. Firstly, we say it is a pure point of law. It doesn't require further factual inquiry, and it involves consideration of the following elements, as we've just seen. The purpose of the authority, that's a matter of construction which was decided below. Whether the right to commission is a qualifying right, again, that's a matter of law on which you've been addressed on. And thirdly, whether a security or proprietary interest is required, again, that's a matter of law. Just in relation to the concern Mr. Moriarty raised about evidence as to factual matrix, very quickly, I should point out that, of course, the reason why the evidence has developed in the way, or not developed in the way that it has, is because, at first instance, the Angove's application was premised on an entirely contradictory way. It was said in the application that the reason why the monies were held on trust was because D&D was an agent. And then, after an exchange just before the hearing, it was a supplemental skeleton was put in to say, well, if the argument is being put that agency does not determine whether the monies are held on trust, in fact, you hold them on trust because you're not an agent. So there was a complete reversal of the premise of the argument. And that, just to for your notes, my lords, that is referred to in the judgment of Lord Justice Patton at paragraph 5.
Right.
Which is at E2, page 138.
Yep.
My Lords, the other point is that in correspondence in February of this year, we asked Angove to explain what new evidential matters they
Yep.
want to bring forward, and no response.
Is that in the bundle or not?
Well, look, I understand that a clip had been produced by Angove's
Well, if
representative.
anyone's going to rely on it, we ought to have it. I'm not saying that we're very keen, but I think if it's being relied on, we ought to see it.
So I had assumed...
No, it's okay, don't worry. There's nothing to apologise for. I just think we ought to see it if it's being relied on. Thank you very much.
If your Lordships turn to page 7 of that clip, you'll
Yep.
see a letter from Shoesmiths,
Yep,
and it's the third paragraph.
as I see. Is there an answer to it?
No.
Thank you. Thank you. Thank you.
Lord, the second main reason for permission is that it would be wholly artificial for Angove to argue for the wholesale application of a general rule without even considering the established exceptions.
I can understand that, yeah.
And thirdly, there's no prejudice to Angove because this is an argument which has been foreshadowed not only by the liquidators, but also was anticipated by Angove in its grounds of appeal at A1, pages 29 to 30, and also in its written case at paragraph 24.
Yes.
And there's, again, there no suggestion as to what further evidence might be necessary.
Yep.
My Lords, that leaves constructive trust.
Yes, it does.
We make two submissions, broad submissions on this issue. First, we say that the Neste-type constructive trust does not arise in this case, and within the context of that submission, we rely on the argument that Japan leasing was wrongly decided. Second, if we are wrong on that primary submission, then we argue that Japan leasing is readily distinguishable on the facts. Turning first to Neste Oy, the important point in Neste Oy is that the sixth payment was received by it in circumstances where the directors had decided to cease trading. The agent, PSL, was not contractually entitled to the payment. In other words, it had just been paid to it to put it in funds to meet, to anticipate expenditure like harbour fees. And there was an inevitable failure of consideration because the payment would not be applied by PSL to meet those expenses. And a fortiori, the directors knew of the failure of consideration, having decided to cease trading. The facts of Neste Oy are unusual. The principal was not contractually obliged to make the payment, and the agent had no contractual entitlement to receive the money. It was a gratuitous arrangement. This unusual scenario is perhaps why Mr. Justice Bingham, as he was, concluded that the retention of the payment when the directors knew that the expenses would not be paid amounted to sharp practice. Japan leasing was very different. Japan leasing concerned the sale of an aircraft by the vendors to Olympic Airways, in respect of which Olympic was making payments. The vendor's agent was authorised to receive the payment instalments in respect of the purchase. The agent remained indebted to the principals under their agreement, and that debt fell to be discharged within the context of the administration. So this was not a case involving a failure of consideration. It was also not a case where the company's receipt of the money could justifiably be said to be unconscionable. This was money to which the company was contractually entitled. So we say there are compelling reasons why Japan leasing was erroneously decided and that it should be overruled. Japan leasing did not involve a gratuitous arrangement, as like the one in Neste Oy. In Japan leasing, the insolvent agent was legally entitled to receive the monies, and in substance, the facts of Japan leasing are not a million miles away from an example in which a large high street retailer on the verge of insolvency receives payments for the supply of goods to which it's contractually entitled, but then becomes unable to pay debts owed to the suppliers of those goods. In the present case, as in Japan leasing, there's been no failure of consideration for two reasons. Firstly, D&D's obligation to make payments to Angove pursuant to clause 22C of the NDA will be performed. Angove will receive a dividend in the liquidation. Secondly, since D&D has arranged the sales which gave rise to the commission, it is acknowledged that D&D is entitled to be paid commission as set out under the agreement. For both these reasons, but in particular the latter, it cannot be said that the retention of the sums paid by the customers is sharp practice and so unconscionable. As Lord Justice Patton found, it was merely a product of the parties' agreement. Turning now to Angove's argument, we say there is an inherent contradiction in Angove's case on this issue because it argues that it is unconscionable for D&D to retain the monies, but the argument proceeds on the basis that D&D was authorised to collect the monies. And in the light of the findings below, it also proceeds on the basis that monies which D&D was authorised to collect were not held on trust for Angove. So in those circumstances, it's difficult to see how the receipt and retention by D&D of the monies could be said to be unconscionable, let alone sharp practice. In support of its arguments that a constructive trust arises, Angove contends that the payments from customers are assets which D&D was under a duty to take for the benefit of Angove, and therefore it would have been a clear breach of D&D's fiduciary duty not to pay them over to Angove. That point is made at paragraph 35 of Angove's written case, and that's where they refer to FHR versus Cedar and Sinclair versus Versailles. But as I've already submitted to your lordships, there is not an obligation to collect in the monies. It is a right, and it's not for the benefit of Angove.
Yes, I mean, speaking of it, a fiduciary duty in this context is misconceived because it's in this particular agency contract, it is simply an obligation to pay.
Yes.
Yes, the duty of loyalty has nothing to do with that.
Yes, and as Professor Reynolds says in his article, because we're not here dealing with pure agency, we're not dealing with an exercise of an authority by a fiduciary, because the exercise of the authority is for the benefit of the agent, not on behalf of the principal. So normal fiduciary straitjackets, if I can put it that way, don't apply.
I mean, the FHR issue, there was undoubtedly wrongdoing, as it were, in the eyes of equity, possibly not merely in the eyes of equity. But here, your point is that this is a contractual right, it's the arrangement between the parties.
Yes.
End of story.
Exactly so. So Angove's argument doesn't hold water because D&D was not collecting an asset which it was under a duty to take for the benefit of Angove, or indeed under a liability under the terms of the ADA. At paragraph 57 of his judgment, the judge at first instance held that Angove does not have a beneficial interest in any sums collected by D&D prior to the termination of its authority. So in other words, monies received by D&D with authority are not held on trust. And again, it's important to note that Angove did not cross-appeal at that point. An argument similar to that relied upon by Angove in this case was advanced before the Privy Council in the case of Lloyd's TSB versus Clark. My lords, that's at F31, page 614.
Yep.
The judgment was given by Lord Hoffman. He identifies the issue at paragraph 2 of the judgment. This was a case which involved a sub-participation agreement, and the question was whether or not the sub-participant bank had a proprietary interest in the bonds, in the bonds or the proceeds thereof, and the relevant provisions in the sub-participation agreement are set out on page 615. At paragraph 6, there's reference to subclause 2.1, which disavows a trustee relationship. It says that it's a debtor-creditor relationship. And then at 7, there's a reference to an obligation on the part of the granting bank to remit an amount equal to the amount received from the debtors. So what was being said was that on the construction of those terms, there was a proprietary right in the sums received by the granting bank. That was rejected, and then we see right at the end of the judgment, in paragraph 27, that an alternative argument was run on the basis of Japan leasing.
Yes.
And Lord Hoffman said, 3 lines down, but their lordships consider, and they think Mr. Milligan really accepted, that if upon the true construction of the agreement, the money was not intended to be the source of the payment to Chase, there is nothing unconscionable about requiring Chase to share pari passu in the distribution of Sybil's assets like any other unsecured creditor. So we say there is no reason to reach a different outcome in this case because there is no trust or fiduciary relationship in relation to these monies.
So is the only way you can justify Neste Oy on this basis was that the payment wasn't contractually due?
There was no contractual entitlement to the monies.
Because that doesn't seem to have been specifically referred to by Mr. Justice Bingham as part of his reason. Is that right? I mean, you can say it's right for a reason he doesn't give or implies. Even Mr. Justice Bingham sometimes doesn't get it right, I hope. But what do you say? What is the explanation for Neste Oy? Why is it right if what you're saying is right?
Well,
is it that the money wasn't contractually due? Or is there some other reason?
Well, the starting point must be that the sums were not contractually due.
That's what I'm saying.
But then the basis for the decision is that there is a vitiating factor, which in the case of Neste Oy was an inevitable failure of consideration. Neste Oy and other authorities has been looked at or interpreted as possibly being explained as a payment by mistake. That in Goldcore, it was interpreted as a failure of consideration. But in Westdeutsche, it was seen as potentially being based on a mistake. And Mr. Justice Mann in Fairpack seemed to, if I can say, run with that analysis in that particular case. And it's interesting to note that in Neste Oy, the claimant applied for permission to amend to claim mistake.
And he was refused, yeah.
Because it was late.
So that can't have been the ground, can it?
Well, if you submit that Japan leasing is wrong, as you do,
yeah,
you must also be submitting that the reasoning of Mr. Justice Bingham in Neste Oy was wrong, whether or not you could arrive at the same conclusion by some other means.
Yes, that puts very well what I was obliquely suggesting.
Well, the only distinguishing feature I would draw to your Lordship's attention is that obviously in Japan leasing there were contractual entitlements to receive money.
But if you look at the actual reasons given
by
Mr. Justice Bingham in Neste Oy, they're the same as the reasons given in Japan leasing. So the reasoning in the two cases stands or falls together. It may be that in Neste Oy you can justify the actual results rather than the reasoning by some other method.
Or Mr. Justice Bingham was assuming, without asserting, that a relevant factor was that it wasn't contractually due.
I think that's why he came to the conclusion that it would be sharp practice, and that then fell into the concept of unconscionability.
He seemed to think that a near miss was something that a decent chap doesn't take advantage of.
Yeah. It's not cricket. Yes, I think that's.
Well, anyway, for your purposes, if saying that Japan leasing is wrong involves saying the reasoning in Neste Oy is wrong, you say the reasoning in Neste Oy is wrong. Yes? If Japan leasing being wrong requires you to say Neste Oy is wrong, you say Neste Oy is wrong.
Yes, we do.
I've written down agreed after a pause.
Always sensible for questions from Ben.
I didn't even have a lunchtime to do so. My Lords, there are policy reasons also why, which militate against the imposition of a constructive trust in this case. We've set those out at paragraphs 92 and 93 of our written case. The one consideration I would want to amplify now is that if Angove is correct in its argument, it has the result of finding that one of an insolvent company's unsecured creditors is elevated above and given super priority to the other unsecureds. And the rationale put forward is that the receipt of the money is either unconscionable or sharp practice, because the company knew at the time of its receipt of its inability to perform its contractual obligations. Now, in our submission, we say that it would be unworkable for office holders to determine which of the company's creditors had been the victim of sharp practice so as to be given this super priority. By definition, an insolvent company will not have performed its obligations to most, if not all, of its creditors. And those creditors will no doubt argue that receipt of sums by the company in the twilight period leading up to insolvency was unconscionable.
Well, they have sometimes to decide whether it gives rise to a proprietary interest or not, and that can be difficult enough.
Quite so, but based on Neste Oy, where the touchstone was sharp practice or unconscionability, that those are subjective and elastic concepts. And faced with the task of applying those as a benchmark for the status of a creditor, it seems that the particular status of a creditor would be as a matter of happenstance.
I mean, your point is a very simple one, that if you transform a personal into a proprietary right, you disturb priorities in an insolvency at the expense of third parties, and that's therefore something that you should not do, save in a case clearly justified by principle.
My Lords, if Japan leasing was correctly decided, we say it wasn't. We say it's readily distinguishable, because in Japan leasing, the judge was initially constrained by the terms of the instalment sale agreement and the vendor's agreement, which expressly disavowed a trust relationship.
Yeah.
And then he went on to consider the particular circumstances of the payments in that case, because he found that the contractual provisions negativing a trust concerned duties arising only from those agreements. So the difference in the agreements in Re-Japan leasing and this one can be identified. In Japan leasing, or rather in this case, there is no contractual exclusion of trust or fiduciary responsibilities. I mean, the reason why His Honour Judge Pelling, at first instance, found that there was no trust was not because he was constrained by the ADA, but he conducted a factual inquiry and looked at the true nature of the position and relationship between the parties and decided that there was no trust. Secondly, it was not part of D&D's agreement with Angove that it would make distributions of the payments it received from the customers up the chain. As we've seen from clause 22, there was an unqualified liability to pay Angove's invoice. That was not dependent upon getting in monies from the customers. Now, we see that was something that seems to influence the judge in Japan leasing. If we look at the authority, which is F4, page 273.
Yeah, well, where do you want us to look? Paragraph or page? Okay.
Well, I just want to take your lordships to page 281 at passage G and H.
Yeah.
He says 3 lines down in that passage, in the present case, the instalment payment was made by Olympic to the company for the purpose of onward transmission to the other vendors. No doubt in the absence of other provisions, that would be capable of giving rise to a trust of the payment in the hands of the company. But then, as I said, he goes on to conclude over the page, on page 282 at H, that there is no trust as arising under the contract. This is at the bottom, because of the express terms. But then he feels able at page 284G to separate duties arising out of the contracts, the documents, and the special circumstances which he says pertains to the instalment payments. So here we have a situation where the judge did the same, performed the same task. He factually looked at the circumstances of the payments, but in this case found there was no trust.
Yeah.
But also he was aided in doing so because under the ADA there was no requirement to pass the payments up the chain.
Yes.
So that's why we say that Japan leasing
Okay.
can be distinguished.
Thank you.
Lords, for those reasons, we say that on the proper construction of the ADA, as at termination,
Yep.
D&D had unconditionally accrued rights to receive the sums. We say that the interest that D&D had in collecting the sums from customers falls within the exception to the general rule, because the authority to do so was granted and exercised to D&D and exercised by it for its own purposes and not for Angove. And also, there's no limit to the exception preventing the retention of commission earned. Thirdly, we say that as the constructive trust issue, this is just not a case in which D&D's receipt of the payment of the invoices led to inevitable failure of consideration or could be said to be unconscionable. Right. It's simply not in the territory of constructive trust. And for those reasons, we invite your lordships to dismiss the appeal.
Thank you very much indeed. Thank you. Ms. Hinks.
Happily, my lords, I can be very brief. Can I? Oh, that's very kind. Thank you. Can I start first with the authority coupled with interest exception? Because whatever the nature of the interest that has to be protected by that doctrine to make the authority irrevocable, I think it's become clear and common ground that on any view, the purpose of conferring the authority has to be to protect the interest, objectively ascertained. And it's inherent in the nature of the purpose having to be to protect the interest that the mutual intention must be, therefore, that the authority can't be revoked summarily. Both those conditions, therefore, need to be satisfied. Can I deal with each of those briefly in turn? Purpose here. I would suggest that for two very clear reasons, it is impossible objectively to regard the purpose of including 22B in the contract to protect the entitlement which we accept they have to commission. The first point is to repeat the point I made in opening about responsibility. In my respectful submission, that language is one of obligation. Now, it's obviously true that the counterpart, or the other side of the coin, to being obliged to collect commission is that you have the power to do so. But it's very important to distinguish between having the power to do so in the sense of a liberty to do so to perform your obligation, and on the other hand, which in our respectful submission this does not establish, an actual right as against the principle, a Hofeldian claim right, as we used to call it when I did undergraduate law, a right to be able to do so that can't be taken away. The purpose of imposing the responsibility upon the agent to collect was for the benefit of the principal. Now, the way in which Mr. Riley tried to explain away the reference to responsibility in clause 22b was to say, well, it's all about risk. It's simply to make clear that they take the risk of non-payment. Now, if you take that to its extreme and test it this way, if all that this particular contract envisaged was D&D, the agent, being responsible for paying the principal, Angove, regardless of when or if it ever collected from the customer, clause 22b is absolutely odious. You don't need it. Because you've got the terms and conditions that entitle the customer to pay D&D, and the obligation of D&D to pay is an obligation that D&D owes under 22C. But there's a much more important point than that, and that's to come back to the point that my Lord Sumption has taken from the terms and conditions. With all respect to Mr. Riley's attempt to explain away the implications of the terms and conditions entitling the customer to pay Angove directly, as opposed to D&D as agent, in our respectful submission, it is an absolute killer blow to the objective intention of the agreement being that they are entitled to have the money paid through them so as to protect their interest in commission. If, in the very agreement that they sign up to, it is expressly contemplated that the customer can pay Angove direct. And Mr. Riley can say and repeat time and time again that there is a deeming of payment in those situations, but the simple fact of the matter, as my Lord Sumption, in my respectful submission, correctly observed, that does not alter the fact that it completely takes away the actual receipt from the customer, which gives the security that's said to be the purpose of the right to collect. And so, particularly when you combine those 2 points, it is very difficult in my submission for your lordships to stand back and say, yes, the reason why 22b there is for protecting the right to commission. And you should be doubly careful, in my respectful submission, about reaching that conclusion against the background of it being Hornbook law, that the default position is, overwhelmingly, that commission is not a right that comes within the exception. If the draftsman here were intending commission to be protected as a result of the right to collect, you'd expect him to be much more clear about this purpose, other than simply putting in the right to collect. And effectively, if your lordships construe this particular agreement as having the effect of conferring a security interest upon the agent merely because it's channeled through the agent when the money's collected, this can be no different from any other contract in which the agent is entitled to collect on behalf of the principal. It would, in practice, drive a coach and horses through what's been understood to be the general position at common law, that commission is not a protected interest for the purposes of that doctrine.
Well, there's a slight difference between commission that has accrued and the future right to commission, isn't there? This is a very narrow, it may be said, proposition in the present case. It's in relation to, it only can't be determined
Yes.
in relation to contracts where the commission's accrued.
I agree that's a distinction. I'm going to come on to whether it has accrued or not.
Yeah, I understand.
But my point still generally remains that when you take into account the terms and conditions that expressly contemplate the right of the customer to pay the producer direct, and the collection obligation being expressed in terms of an obligation, a responsibility, rather than a hotel room right, that strongly points against the purpose being established.
If it was spelt out in clause 22C that the only way in which D&D would get commission was through deducting the amount from the payment to Angove. Would your argument still be the same?
My argument would be less strong, but I think it would still be the same, yes. It might be a factor which will make you more inclined to see the purpose being to protect, but it might just simply be a contractual mechanism.
Okay.
And my Lord Newberger said, well, it may well be that the terms, because you sit a bit awkwardly, but the fact is you've got this scheme in 22A, B and C. In my respectful submission, you can't simply park the terms and conditions as being some collateral point that doesn't have a bearing upon this question. You've got to construe 22B and what it means in terms of the entitlement to collect and the purpose which that entitlement to collect was conferred against the background of the very terms and conditions that the parties contemplate being the basis of the contract with the customer, giving an entitlement to pay direct. You simply cannot square those two, marry those two up if the purpose was to protect the right to commission. Can I move on to a slightly related point, which is Mr. Riley also said that in the clause 22C, the entitlement to be paid by Angove is simply an entitlement under 22C that doesn't involve any obligation of D&D as an accounting party as agent. And he said, furthermore, that was exactly what the judge decided at first instance, because the judge said that the money wasn't being collected and held by the agent D&D on trust. Now, it's absolutely right. There was an issue before the judge at first instance as to whether or not the money was being collected by the D&D on trust for Angove, and the judge decided it was not. But that's not the end of the story. Let's also see what he did say about the basis upon which the money was collected. And to that, we need to go to pages 174 and 175.
Thank you.
In the judgment?
Of the judgment at first instance.
What paragraph?
Paragraph 46.
26?
46 and following.
46, sorry.
And you can see that at 46, the judge recalls that D&D disputed, even that there was a duty to account, and it made the submission that was being made by Mr. Riley this afternoon. But he observes at 47, in that context, the effect of the clause is clear. It is to impose on the company an obligation to collect the sums due to Angove from third-party purchasers where the company is acting as Angove's agent, as was the case in relation to the transactions relevant to these proceedings. And then he goes on at 49, therefore, to explain in his judgment how the accounting obligation under 22B sits with the obligation in 22C. He says the primary obligation to pay rests on the third-party purchaser. If the company is successful in collecting the price payable, then it must account for the sums collected to Angove. In the event that it is not successful in collecting what is due to them, then an obligation to indemnify by paying by the due date arises. So the judge is saying, and in my respectful submission, it actually is correct, that the way in which you analyse the legal relationship between 22B and 22C is that 22B is an obligation owed on a fiduciary basis by D&D to collect debts from the customers for Angove, and once collected, he has a duty to account for them, which is of a fiduciary nature. But in the event of them not being collected in time, within 90 days, then you effectively have the secondary obligation under 22C to pay notwithstanding. Can I then finally... Oh, no, one other, when does the right accrue? Because if I'm right on purpose, then the accrual issue doesn't arise at all. But if I'm wrong on purpose, then the accrual issue is of relevance, because it is of relevance as to whether or not the parties are to be regarded intending the right to be irrevocable. Now, the question therefore becomes, at what point does the right to recoup become irrevocable? And it's very important in my respectful submission to draw a clear distinction between the question, when does the right to commission accrue, and when does a right to collect money from the customer accrue? Now, we accept, I think it's common ground, that the right to commission accrues when the sale contract's concluded. But that's not the relevant question. The relevant question is when, given that they're given a right to collect, or that they're given a responsibility of collecting the money from the customers, at what point do you say that that is written in aspic and accrues so that it is no longer affected by a termination of the authority generally? And our submission will be that the only sensible time at which you can say the right to collect from the customer accrues so that it can't be terminated is when and after the agent has accounted to Angove for the money under clause 22C. Apart from anything else, particularly bearing in mind we know that there is the possibility on the contractual arrangements that are agreed to that the customer may decide to pay Angove direct. Plainly, until Angove has actually received payments, whether from the customer or from D&D, it doesn't make sense to say that they've got an accrued right to go and collect. And if that's correct, and I don't think ultimately Mr. Riley addressed the question directly, if that's correct, then plainly there can't have been an accrued right in this case, which therefore makes the authority irrevocable, because the parties intended accrued rights to be protected, for the simple reason we have not been paid by D&D under clause 22C. That's the problem. We want the money. So for both of those reasons, I respectfully submit that they simply can't bring themselves within the authority.
So just to clear up one point.
Yeah.
There is they agree, the D&D agree with a client, with a customer, that the customer will buy, the goods are supplied, before 90 days are up.
Yes.
D&D become insolvent. The contract ends, never mind why. The 90 days then come and the customer hasn't paid. Is there a liability on D&D to pay Angove?
I'm accepting for the purposes of this argument that there is.
I see.
But I'm saying that although there's a liability upon D&D to pay, it doesn't, which gives them an interest in, if they pay, collecting the money from the customer, that entitlement to obtain recoupment from the customer as a result of it having a liability to pay me, Angove, doesn't accrue until they've paid me, Angove.
I see. Cool.
So if the contract is terminated before the 90 days are up, the obligation to pay out of the agent's pocket ceases with the other.
No. No, he's saying it doesn't.
You say it does. You say it continues.
My primary case is it doesn't continue. But if
I see. Sorry, I thought you were saying.
No,
that's what I asked you. And you
no,
said
so I'm sorry. No, but if it does continue, if it
continues, you say that it accrues when the payment is made.
Yes.
But as I understand
the right to collect accrues when the payment is made.
But as I understand your primary case, it is that if the buyer, if the 90 days hasn't elapsed when the contract is terminated, then the obligation to pay after 90 days if the buyer doesn't.
Yes, I'm sorry.
Does that lapse or not?
No, that does lapse because it hasn't accrued.
That ceases with the termination of the.
I didn't appreciate the distinction between termination taking place before they've received payment, but before 90 days have expired. No, I would essentially submit that on the proper interpretation of the agreement, if termination of the agreement takes place before the 90-day period is expired, then the obligation to pay.
So there's it's not an accrued right.
It's not an accrued right of Angove.
I think that logically that position must be so if you are right on your other submission.
Yes.
Yes.
That's why I asked and was surprised.
Sorry, I didn't appreciate the subtlety of the distinction, but I now see the point. Can I then, I think, finally, that really parks why we say for two reasons, which if I win on either of those two, means that don't come within the authority coupled with an exception, but authority coupled with an interest exception. That then does leave what I understood to be a wider submission based upon Johnson and Agnew, which is basically let's create a new exception to the common law rule that authority is irrevocable even if it's a breach of contract. And the argument appeared to be that just as in contract, an accrued right is not adversely affected by the termination of the contract going forward, so in principle, there is no reason why the same carve-out shouldn't be made in relation to an authority. But in our respectful submission, a number of points about that. First of all, and most fundamentally, that is still ignoring the basic distinction in our respectful submission that underlies the difference between the ability to revoke authority on the one hand and the inability to breach a contract on the other, which is authority is revocable inherently, subject to coming to the exception, for the reasons that Mr. Riley showed you when he went to the restatement. And he said, why is it important, as a matter of principle, for Angove to be able to call back the authority which was conferred under the agreement? Well, the answer to that is quite simple. The reason why it's important for Angove and any other principle in this situation to be able to call back the authority of an agent when he's insolvent, if he's entitled to do so under the agreement, or even if it's a breach of the agreement, is to stop what's happened in this case. It's to stop the agent who is only entitled to collect debts belonging to somebody else, carrying on collecting them when he's insolvent, and using it to allow his own general creditors to snaffle the shows in action belonging to the principal. That's the reason in our respectful submission why, unless you come within the specific exception of authority coupled with an interest, which is really, as the cases that Mr. Riley showed you show, is where the agent is not really an agent at all in the sense of owing fiduciary duties to the principal. Unless you come within that very limited exception, it is very important in our respectful submission for the common law principle for good reasons to apply. And lastly, I'd simply say, if you accede to the submission that Johnson and Agnew has the effect that even if the purpose of conferring the right to collect wasn't to protect any entitlement to commission, you are creating, for the first time, a novel further exception to the general common law rule, for which, in my respectful submission, there is no basis whatsoever in either principle or policy. And those were going to be my submissions. And that's it.
Thank you very much. Well, thank you very much indeed for your oral arguments, which we found very helpful. Thank you also to those who were responsible for the written cases, which we found also helpful. We will consider this matter and let you know our decision in due course. Thank you all very much indeed. Court is now adjourned.